Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney, Ms. Murthy, to discuss the latest updates on immigration, followed by frequently asked questions related to H-1B, GC, and other immigration matters. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We will start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. For case-specific issues or concerns, please reach out to attorneys for a private consultation. Hi, Ms. Murthy. How are you doing?
Good. How are you today, Ranjit? And good afternoon or good evening to all of you. Regular subscribers. We're happy to be here today. And I know, Ranjit, you always ask me to do a brief introduction of myself and the firm. The Murthy Law Firm was started 27 plus years ago with the goal of helping, educate, empower, enlighten, and enrich you with the latest information on immigration law to guide you and to make you realize that you are not alone on this journey, that as a community, we are all here to take care of each other and support each other along life's journey and along this immigration process. So please take advantage of the free Murthy Bulletin, the free chat, the free forum, all of the wonderful resources, because we are literally spending thousands and thousands of dollars each week in attorney time just to help people like each and every one of you that is going through the immigration law process. With that, Ranjit, I will let you do some of the other introductions that you always do.
Yeah, you all know very well, Ms. Murthy is the founder, president, and CEO of Murthy Law Firm, and she's a Harvard Law School graduate. Also, she's the one behind the famous Murthy.com website, where you can go and check all the latest updates and frequently asked questions and a lot of advices from attorneys. A lot of people were asking Ms. Murthy about the filing fee for I-765 and I-131, that is Advanced Parole and EAD. I know there is no fee filed with 485. But do we have to pay a separate fee? Let's say if someone has not filed with 485, but they want to do it like later at any point of time, do they have to pay a fee for that, or how does it work?
So depending on when the case was filed, there's no fee or a fee, because one of the things that the CIS ombudsman had created years ago was to just have one flat fee, which included all these other fees, with the goal that if we can approve the 485, we can save a lot of money. But then typical USCIS, they start delaying and they create a monster on their own, because by delaying so much, people then have no choice but to then start paying for the premium processing, which we know can be up to $2,500 or $1,500 for separately on top of all the other filing fees. Plus, USCIS now wants to again create separate fees for each of those processes, when the reason was that it was combined to make it so that they could get profits and minimize their work, and in many cases not even have to issue EAD and AP if they can approve the 485 directly. So now they are looking at having a separate fee. So depending on when you filed it, if you are subject to the separate fee, then you have to pay it. If you're not going to be subject to the fee because yours wasn't that bundled package, then you're exempt. And now the premium processing is completely separate, and they are definitely adding between 15 or up to 2,500 in some cases, on top of all the other fees that you have to pay. Fees are something that the government keeps changing. And I often say, if you and I ran a business like that, nobody would be our clients. But for the government, they have a monopoly. We are all at their mercy. And the more incompetent they are, they seem to be rewarded with higher and higher fees, which in my opinion is truly unfortunate, because one of the greatest things about America is its efficiency and its focus on customer service and taking care of people. All that was completely lost in the last 4 or 5 years, when the focus became less about serving the clients or customers, taking care of employers, employees, families going through the immigration process, and treating the whole immigration system as if it is a burden on the US taxpayer, when it is the exact opposite, when we all know that America is a nation of immigrants, that each of you as people that are immigrants coming in have created jobs, paying taxes, helping the economy, doing so much good for the United States of America, that it's extremely important for us to say thank you to each of you rather than making it sound like it's a burden.
Thanks, Ms. Murthy. That's we have the caller Nag again. Hi Nag, welcome to the show. Please go ahead and ask your question.
Sure. Yeah. Thank you for taking my call. Hi, Ms. Murthy. How are you?
Hi, Nag. How are you?
I'm good, thank you. My question is, my priority date is September 2015 in EB2, and when I looked into perm application, the form 9089, for one of the companies, I worked from 2013 until 2014, but in perm, it was there was a typo that is saying from 2003 to 2014. Will it cause any issue when I file 485 with EB3 downgrade?
And you're going to apply based on that same employer, the perm on which you're going to file the EB3 downgrade is based on that perm case?
Yes, yes.
Okay, so yes, absolutely. Any mistake that happened before, it's an automatic red flag, and they may still pick it up even in your case, even with if you do an EB2 case in the future and file it, they may realize or ask questions about your 11 years of experience before. But if you do an EB3 downgrade, it is absolutely like a red flag, like you're waving a red flag and bringing it to the matter to their attention, because that is not considered. If you look at the Department of Labor cases and BALCA, the Board of Alien Labor Certification Appeals, when they make decisions, Nag, they definitely say that there is nothing like a typo. The typo belongs to you, either the employer or the attorney. And if that's a company's employer's mistake or the attorney's mistake, somebody didn't catch it. And therefore, you will have to face the burden of that. And the worst thing that could happen, of course, is not only if you don't get the EB3 downgrade or the EB2, that you won't even get the priority date that you can now transfer to another case in the future, because this is a clear error and it is a substantive, potentially substantive error, and not just some type of an obvious small glitch, right? Because when you say there was a typo, the government says it's your job to check it. It's employer, attorney, and employee. Everyone should be checking that big problem. So there's a very big risk for you in this case, Nag. I don't know if you want to take a risk with a downgrade at this time and discuss it with your company lawyer. I'm sure they've pointed out the risks to you as well and how best to minimize it, or maybe to do a fresh perm and try to port the date to a new perm case, maybe do a brand new fresh green card case so that this doesn't come back to possibly even haunt you. Even though I know it's a waste of time and money, it may be one of your options to consider.
Thanks, Ms. Murthy. Thanks for your advice. We have another caller, Sandeep. Hi, Sandeep. Welcome to the show. Please go ahead and ask your question.
Hi, Ranjit. Good afternoon, Ms. Murthy. Thanks for taking my call.
Hi, Sandeep.
Hi. Ma'am, my priority date is August 2011, and I've already received my EAD card. And again, I mean, like my priority date is current with the new latest bulletin. So the thing is, I'm in a position where I mean, like I need to travel to India for my wedding. So with the GC imminent, I'm not sure if I mean like, and also with all the travel ban and the consulates closed, and the problem is I have a H1B which just expired a couple of days ago, but I have an I-797 approved. But if I were to travel to India, I'm definitely going to have to go to the consulate for an appointment. So the option that I came across was to have a virtual wedding here through the state of Utah, which actually arranges a ceremony for two international, like a bride and a groom in different locations within the world. They can get married over a Zoom call, and again, the marriage certificate is a valid, and it is apostilled, is the term that they gave me, by the state of Utah. So I was wanting to understand if this is something that you've come across, and if this is a marriage certificate can be produced by my spouse for a H4 interview. I'm not even sure if a H4 interview is possible at this point of time, but that is something that I'm looking at, and I wanted to know if this is something the consular officer will accept it, and if there is any other option that you can see to help me.
So that's a great question. So by law, what the USCIS does is they're supposed to, under principles of comity and under principles of good faith and full faith and credit, they do recognize laws of other countries, other jurisdictions. For example, in some religions like the Islamic faith, the nikah can be where the husband and wife are not together. But in general, whether it is Hindu Marriage Act or Christian Marriage Act or Special Marriage Act in India under the Indian laws, or under US law, which generally almost always requires both the husband and the wife to be physically present in person for the wedding to take place. So I am not very familiar with the Utah marriage and whether this is something new that because of COVID-19 that they have created this new Zoom wedding. So if that is indeed, if it is an absolutely valid, legitimate, legal marriage, then you would certainly be able to argue at least that, hey, we were married, because the risk, of course, in a case like yours, as you can imagine, is if your 485 gets approved, then your spouse can no longer come and join you on H4 status because you are no longer on H1B the day on, which is tomorrow. If September 1st, your priority date becomes current and the USCIS approves your 485, that's it. Yeah, unless you get married today, and it's already, today is already tomorrow in India, so it's already too late, because if the approval notice of your 485 is dated, so it depends if you're able to beat the clock even by a day. So if somehow you're able to get married and bring your spouse on H4 into the United States, which again, like you said, because of the presidential proclamation, consulates working not full time, but on a much more reduced basis, whether you're able to get a visa appointment on an emergency basis, get the national interest exception of applicable for your spouse, for your wife to join you, get the visa stamp, and then travel to the United States, come in, and all that technically has to happen before your 485 gets approved. So you are definitely dealing with a severe challenge here. We knew that the priority dates would move at least to some extent. And, on a case like this, it's you really probably need to sit down very carefully, figure out the legal ramifications. Hopefully you've talked about this with the employer and the employer's attorney. And I don't think that we should be in a call like this where you have 1 or 2 minutes to go over it and to look at the risks, talk about it, because I don't know enough about Utah law, and I'm certainly not a lawyer. I'm admitted in New York and Maryland, in Washington, D.C., the U.S. Supreme Court, and in India, I was admitted as a lawyer. But I would be, I think any lawyer would hesitate to say, yes, go ahead with X or Y on something like this that is a life and death matter, that is your marriage, that could be a spouse, because otherwise you could be separated from your spouse for a couple of years while you file the I-130, try to bring her in, assuming that the priority dates for permanent residence remains current. But that's not the best way to start a married life together, where both parties are separated from each other for months, if not years. So please make sure that you are looking at the legal documents, maybe get a legal opinion, attach that to your documents if you're trying to apply for the H4. And again, I don't even know that the consulate will be able to do that or accept or acknowledge a marriage like this, especially if it's something brand new that's just been done recently over the past few weeks because of COVID-19.
One thing to add here, Ms. Murthy, if he had, I'm not sure if Sandeep has an advance parole, but if you have an advance parole, I believe he can travel and come back. I forget about spouse, because
I was thinking of that for him, but that will not help his wife at all.
Yeah.
Come in. So yes, I did think of the advance parole if he has it, but that will not allow his wife to join him. In fact, if he uses the parole and comes back, they potentially could say that since he did not enter on H1, we could potentially deny the H4 for the spouse. Now, if he's got the H1B approval and they show the marriage, the wedding, and she's able to come in before the 485 gets approved, there's an argument to make. But again, that's what I mean, because there are so many gray areas and nuances on this issue. I'm very concerned, because if he's going to rely on this to make a decision that can deeply impact his life, his married life, his good, his relationship with her family, his family, and everything, I
Yeah,
would
true.
absolutely spend more time doing a much more in-depth research and analysis.
Yeah, I think it's better Sandeep consults an attorney and takes decision, especially with this pandemic and almost very limited appointments everywhere in the world. So that's the big challenge here. And now that your date is current, and there is a good possibility his I-485 could be approved in the next 1 month. So I mean, this
Especially
is
because they're trying to finish hundreds and thousands of cases right now
yes,
on an expedited basis because they don't want to, because of the lawsuits
waste.
pending, and they don't want to waste the unused immigrant visa numbers.
So yeah, I think it's kind of a very tricky situation. So probably you should consult a lawyer and get
Maybe
an
we'll be able to
information.
do it, but somebody would have to actually research and look at that, look at the Utah law, look at that, make sure that we at least, or talk to a Utah lawyer who can give a legal opinion that this is a legally binding marriage under Utah state law,
But
rather than
even
just something
then,
on the internet.
the problem is to get an interview in India. That's the whole point here, right, Miss Murthy? Otherwise, he could just go
So
travel,
that
get
is one of
married,
the
and come back.
factors, because to tell you the
Yeah.
truth, if the marriage in Utah is 100% legit and recognized by the United States Department of State, by the US government, under the state of Utah, based, because almost every single time there is no exception to physically requiring both parties in the marriage to be physically present at the time of marriage. We have done a lot of research on this over the last 30 years.
I
So
know.
there's lots of gray areas involved. Assuming if that is a valid and legal and bona fide marriage, then the appointment issue is less of a concern if they can do it, but at least they have to be married. And then they would apply for the visa and try to come in before his 485 gets approved. But if the 485 gets approved, then there's no question of H4 anymore.
Yeah, true. That's a lot of twists and turns here. So yeah, you should definitely consult an attorney. Ms. Murthy, we have another caller, Kiran. Let's take the call. Hi, Kiran. Welcome to the show. Please go ahead and ask a question.
Yeah, thank you. Hi, Murthy. Thanks for taking my call. My question is regarding H-1B transfer. Actually, I am working with as a model like employer and client model. So my I-140 and H-1B extension is approved with employer, and I got a full-time opportunity in B company, and I'm going to join that company in 2 weeks. The transfer is approved well. Now I have informed to my employer and client that I am leaving. So the client is want me to take a full-time opportunity, and employer also doesn't have any problem. But if you have a multiple H-1B transfer, is it cause any problem or anything?
So Kiran, it shouldn't matter. You're saying you are working with employer A, you got a job from employer B. Now employer A's client is offering you a job as the new H-1B employer C. Because you're filing with a new employer and you get a new H-1B approval with USCIS, Kiran, you're worried if that's going to cause a problem. So as long as it's filed, and ideally you want to wait for it to get approved with the client of company A, so that only after you get that, then you join them, rather than trying to join based simply on filing the petition, because if it doesn't get approved, then you will lose the job with employer A and with employer B, and then potentially with employer C, if it doesn't get approved, you get an RFE or a denial. So, but there's no restriction on how many H-1 petitions employers or H-1 petitions an employer files for an employee. So that is not legally a problem, Kiran. Good luck and congratulations on getting so many job offers.
Thanks, Ms. Murthy. We have another caller online. Hi, welcome to the show. Please go ahead and ask your question. Shiva, are you there?
Hi,
Please
ma'am.
go ahead and ask your question.
Yes.
Hi, Shiva.
Hi, ma'am. Good afternoon. Actually, I'm on H-1B,
Shiva.
ma'am. Actually, my max out is next year, October. And meanwhile, I need to get my 140 approved. My current company has started a prevailing wages process last month, actually. And actually, what happened is my previous employer has filed when I was there for a labor, and that is approved in April this year. So can I use that labor? Is there any way I can use it, like a future employment or H-1B concurrent? with my previous employer. And
Shiva,
what
the only
are
way is
the
that the prior employer has to file the I-140 petition based on that previous labor approved in April. And as you know, you have only 180 days for the validity of the labor certification. So you absolutely
correct.
need that prior employer has to file the I-140 petition immediately before the 180 days expires, so that you can lock in, get the approval, I-140 approval, and then you can port that priority date or use that to get H-1 extensions in the future. And you can negotiate or discuss with the prior employer that you will go back and work with them if that is your intention and your goal, to genuinely and honestly go back to the prior employer. Because otherwise, if you're just doing the prevailing wages now, you will not be able to stay in the country. You'll have to pack up and leave the United States next October unless your perm and I-140 both are approved. And right now, as you know, just the prevailing wage determination itself can take several months, 3 to 6 months or longer. Plus, after that, the perm has to get approved, and then the I-140 petition has to get approved. So honestly, it wouldn't make sense to rely on this current job. And, ideally, you should have thought of this before changing employers. But if the prior employer has the perm, use it, negotiate with them, ask them to file the I-140 petition. And if the option is that they are forcing you or requiring you to go back and work with them in order to file the I-140 petition, you have to make a decision whether leaving the country for a year makes more sense for you and your family, or going back to the prior job, getting the I-140 filed, hopefully approved, and then using that priority date in the future, either with the same employer or with another employer.
Thanks, Ms. Murthy. Thanks for your advice. We have another question offline that a lot of people were asking. There is different information and different sources, especially for the renewal of the 485 EAD. Let's say earlier they used to give only for a year. Let's say someone is going to expire soon, they have to file a renewal of I-765. Do they have to pay fee for it? Some people say there is no fee for a renewal I-765, and some people say you have to pay renewal. So
it depends on which one you did. They were prior to them combining it all together in one form. They were separate fees. So it depends how long back you filed it.
I mean, let's say this year, like in the last October, whoever have filed their 765 is due. So do they have to pay fees? Because I don't know when that the fee structure has started or changed.
So presumably that's what it absolutely depends. So if they filed it last October and they were then subject to separate fees, then each time they do the 765, they absolutely have to pay it. If on the other hand, they did it where it was a one lump sum application to cover everything, then for renewals, you don't have to. But that's what I was talking about earlier, because the USCIS originally, everything was separate. We used to pay separate fee for every process. Then they decided to combine everything, and they added the fee for 765 and advance and made it a very much higher. Before, the 485 fees was like 300-400. Then they made it like 1,000 to include all EAD, AP, everything, right? And then they realized, oh wait, now we can again make more money if we separate it. And so they left the 485 fee as it is and added separately again new for 765 and new advanced parole I-131 fees. So I tell people, look at what the date you filed it, look at the rules and the regular, what was applicable on the day you filed it. And so there should be no shock or surprise factor. It depends on what time they filed it and what the rules that were applicable to that particular family on the date that they filed it. Because the USCIS is very clear, this flat fee covers everything or it covers nothing.
Thanks, Ms. Murthy. We have another caller, Thiru. Hi, Thiru. Welcome to the show. Please go ahead and ask your question.
Yeah. Hi. Thank you. Thank you, ma'am. I have a question regarding my priority date. Basically, my 140 got approved in the month of September 2018 in EB3 category. So I would like to know what's going to happen in the coming visa bulletin. I'm eagerly waiting for the October bulletin to come to see if I can apply for the 485. So do you have any insights into what's going to happen in the next month? That would be great.
So yeah, we keep
Thank you.
sharing, Thiru, we keep sharing all the insights on a very regular basis through the articles that we write. If you're subscribed to the free Murthy bulletin that we put out and the Department of State updates that we put and the Murthy.com website, we put what the latest is going on, what is the expectations, what are the predictions. Maybe you have also signed up, if you haven't signed up for the monthly conversations with Charlie Oppenheim, it's called Visa Bulletin Updates with Charlie, who is the chief of the Immigrant Visa Control Unit at the US Department of State. He is the person in charge in the country for determining or helping with the movement of priority dates based on discussions with USCIS, the usage of immigrant visa numbers, what is going on worldwide, how much is being used in family-based cases at consular, US consular posts worldwide, as well as USCIS, giving them guidance on whether they can move and how fast, or whether they can use dates of filing or final action dates. So all of those latest things are being shared by Charlie in the monthly bulletins, and we are summarizing those in very simple, short, easy to understand language on Murthy.com. So this is something that when people say, do you have, Ms. Murthy, you've been doing this for 30 years, can you please give us a prediction? No one can give you a prediction and a guarantee. Not even Charlie Oppenheim, who does it for a living, can give you 100% guarantee on what will happen. So we tell people, look at what he's saying. He just started this few months back, these monthly updates. Listen to those if you have the time. Look at the Murthy.com updates. See what Department of State in the monthly visa bulletin, they are giving you advice and hint on what is going on and what we expect. So monitor it, but again, remember, it is never 100% guaranteed till the visa bulletin actually comes out. And you said that your EB3 got approved in September 2018, but obviously it's not the approval date of your I-140 petition, Thiru, but the priority date of when the perm was filed with Department of Labor that gives you your priority date, even though it's finally stamped and recognized at the time of the I-140 approval. So the priority date will determine whether you will be eligible, you and all your dependent family members, derivatives, will be eligible to file the 485s in the United States at that time. Good luck. I hope it works out for you, Thiru.
Thanks, Ms. Murthy. We are towards the end of the show. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy. Again, it's every Tuesday at 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Ms. Murthy. Bye-bye.
Thank you very much. Bye-bye.